In addition to these general principles, the European Court of Human Rights has developed a series of specific considerations that come into play when assessing defamation cases. First and foremost among these is the protection afforded by the court to political speech. Mindful of the importance in a democratic society of the right to freedom of expression, the court often repeats the statement that freedom of political debate is at the very core of the concept of a democratic society, for example, in Lingens v. Austria. As the court elaborated in a more recent judgment, the court emphasizes that the promotion of free political debate is a very important feature of a democratic society. It attaches the highest importance to the freedom of expression in the context of political debate and considers that very strong reasons are required to justify restrictions on political speech. Allowing broad restrictions on political speech in individual cases would undoubtedly affect respect for the freedom of expression in general in the state concerned. This is from its 2001 judgment in the case of Feldek v. Slovakia. This has particular implications for politicians who, the court has held again and again, must be extremely tolerant of criticism made of them. Were this not so, politicians could easily abuse defamation laws to shield themselves from criticism. The reason usually given by the court for this enhanced scrutiny is that politicians have voluntarily entered the political arena. So in the case of Oberschlick v. Austria, the court said, "The politician inevitably and knowingly lays himself open to close scrutiny of his every word and deed by both journalists and the public at large, and he must display a greater degree of tolerance, especially when he himself makes public statements that are susceptible of criticism." Correspondingly, there is also a wide privilege for political debate. This extends to reporting of what is said in Parliament or other bodies covered by the same privilege. And as a general principle, not only would a member of Parliament not be liable for a defamatory statement made in Parliament, neither would a journalist who reported that statement. The European Court of Human Rights has generally been very firm in upholding this principle of parliamentary privilege in defamation cases. In the case of A v. the United Kingdom in 2002, the court explained that while freedom of expression is important for everybody, it is especially so for an elected representative of the people. Accordingly, interferences with the freedom of expression of an opposition member of Parliament call for the closest scrutiny on the part of the court. The principle that political speech should be protected is well established, both at European level and in many national jurisdictions. It is curious then that it should continue to coexist with the notion that it is possible to defame or insult officers, institutions, or even symbols in many European countries. A number of such cases have come to the European Court of Human Rights. One notable example is the case of Aon v. France. In 2008, the French political activist Hervé Aon waved a small placard as a group of people, including the president, Nicolas Sarkozy, approached. The placard read, "Casse-toi, pauvre con," which means, "Get lost, you sad prick." These words had previously been spoken by Sarkozy to a farmer who had refused to shake his hand at an agricultural show. Aon was charged with insulting the head of state. Under this charge, there is no possibility of pleading truth, unlike in an ordinary defamation case, and Aon was convicted and a suspended fine was imposed on him. After appealing unsuccessfully through the national courts, the case went to the European Court of Human Rights. The European Court found resoundingly in Aon's favour, and it concluded that the repetition of the phrase previously uttered by the President cannot be said to have targeted the latter's private life or honour, or to have amounted merely to a gratuitous personal attack against him. The applicant's intention was to level public criticism of a political nature at the head of state. In another case, involving insult of a head of state, the European Court of Human Rights was similarly firm in ruling that a state had violated the right of freedom of expression. The case of Otegi Mondragon was from Spain, where the head of state, the monarch, is not a politician but plays a constitutionally neutral role. Mondragon, who was a Basque nationalist politician, had been charged with insulting King Juan Carlos when he identified him as the head of a state that tortured Basque nationalists and gave immunity to torturers. Although he was acquitted by a Basque court, a higher court on appeal convicted him and sentenced him to a year's imprisonment, also removing his right to stand for election. The European Court of Human Rights held that this violated his right to freedom of expression. It stated that the fact that the king occupies a neutral position in political debate and acts as an arbitrator and a symbol of state unity should not shield him from all criticism in the exercise of his official duties, or, as in the instant case, in his capacity as a representative of the state, which he symbolises. In particular, from persons who challenge, in a legitimate manner, the constitutional structures of the state, including the monarchy. The fact that the king is not liable under the Spanish constitution, particularly with regard to the criminal law, should not in itself act as a bar to free debate concerning possible institutional or even symbolic responsibility on his part in his position at the helm of the state, subject to respect for his personal reputation. In a judgment more than 20 years ago, the European Court of Human Rights took the notion of protection of political speech a step further. The case concerned an Icelandic writer named Torgeir Torgersen, who had written press articles about the issue of police brutality towards suspects. He was convicted in the national court on charges of defaming members of the Reykjavik police force. When the case came to the European Court, the Icelandic government's lawyers argued, amongst other things, that this case was distinct from earlier European court cases, such as Lingen's, because it did not involve political speech, which the court has found to be especially protected. The court was not persuaded by these arguments, and it used its judgment to develop a new doctrine, which has been referred to in a number of subsequent cases. It spoke of the importance of the role of the media as a public watchdog on all matters of public importance, not just politics, but also other matters of public concern such as police brutality. It held that, whilst the press must not overstep the bounds set inter alia for the protection of the reputation of others, it is nevertheless incumbent on it to impart information and ideas on all matters of public interest. Not only does it have the task of imparting such information and ideas, the public also has a right to receive them. Were it otherwise, the press would be unable to play its vital role of public watchdog. The press should still, however, act in good faith and in accordance with generally accepted rules of journalistic ethics.